Hello guys, welcome to our channel. Today in this video, we will discuss the exciting news of the Ripple vs. SEC lawsuit. But before we start the video, make sure to give us a big thumbs up, and if you are new to the channel, don't forget to subscribe before leaving. Also, hit that bell icon so that you can get notified whenever we will upload a new video. For now, let's get back to the video straight away. Ripple's XRP crypto token rose by as much as 20% on Tuesday, as the payments company made headway in its ongoing court battle with the U.S. Securities and Exchange Commission. According to the court documents, Judge Annalisa Torres, late last week, said she would allow the unsealing of some documents relating to the case, which has been running for over a year and relates to how the XRP token was marketed. XRP shot up from 60 cents on Thursday to 90 cents at one point on Tuesday, according to CoinMarketCap. XRP dropped slightly from these highs on Tuesday to sit at 85 cents at around 6:15 a.m. Eastern Standard Time, representing a 12.6% gain over the previous 24 hours. Overnight, further updates on the SEC vs. Ripple case were also XRP positive. The crypto markets reacted favorably to news of case judge Annalisa Torres granting a number of motions in favor of Ripple. FX Empire analyst Bob Mason wrote, "Ripple was not immediately available for comment when contacted by Insider. Ripple has been engaged in a legal battle with the SEC as of December 2020 over whether XRP should be treated as a security or a cryptocurrency. However, Ripple executives Brad Garlinghouse and Christian Larson have always maintained it's a cryptocurrency and therefore not subject to the same regulations as stocks." In a decision late last week, Judge Torres ordered the unsealing of 3 documents, including email threads from both executives, as well as allowing Ripple to maintain its fair notice defense, under which it can say if it had fair notice or not from the SEC over whether its XRP sales constituted security sales. The SEC has previously moved to strike such defense or remove it from the record. According to the cryptocurrency commentator and legal partner at Hogan Legal, Jeremy Hogan, the fair notice defense is crucial. If Ripple wins on the fair notice defense, it becomes a persuasive authority for any crypto company the SEC sues from this point forward. If the fair notice defense survives and Ripple wins, the SEC is going to have an uphill battle winning any other lawsuit they bring, Hogan said as part of an update on the case last May. Meanwhile, the cryptocurrency market rallied modestly on Tuesday, with Bitcoin up around 2.6% at $43,822 and Ether up 1% at $3,105, according to CoinMarketCap. XRP vs. SEC Ripple lawsuit has managed to grab the interest of every crypto enthusiast. Ripple has managed to win a small key battles step by step within the case, while SEC has been jumbled into their contrary statements. Towards the end of 2020, United States Securities and Exchange Commission filed a lawsuit against Ripple and its officials. SEC alleged that Ripple's XRP token is a security, and Ripple has traded XRP tokens worth over $1.3 billion. However, Ripple did not accept the allegations and claimed that the trade was purely legal, as XRP does not come under the securities. Is the SEC biased over ETH? In its defense, Ripple raised a critical objection: why SEC is considering XRP as a security while leaving BTC and ETH of it. Ripple chief Brad Garlinghouse even called out the SEC in public and claimed that the agency is biased as it helped ETH to surpass XRP. Here are a few key events that raise question marks on how the SEC handles this lawsuit. In June 2018, William Hinman, former director of SEC, publicly said that the commission would not be treating Ether or Bitcoin as securities. As per reports, Ethereum Foundation bagged over 60 million funds by selling ETH coins. In 2018, Gary Gensler, then a professor at the Massachusetts Institute of Technology, argued that Ethereum violated federal law by issuing $18 million in tokens, and that too, without registering them as securities with SEC. In 2022, Gary Gensler, chief of SEC, seems to forget what he said back in 2018. In a recent interview, he looked hesitant to reply to a question concerning the difference between Ripple and Ethereum using their tokens in public markets. Case revelations helping Ripple. To date, the Ripple vs. SEC lawsuit has seen many big revelations, and the XRP defendant believes that there are more to come. Every disclosure related to the case has only benefited Ripple and proved to be a big mistake done by the SEC. Recently, case judge Annalisa Torres delivered some orders in favor of Ripple. After the mystery of these 2 sealed memos, the Estabrook notes have increased the problems of the SEC in the case. These notes were taken then to the counselor, Commissioner Roseman, Matthew Estabrook. It is believed these hold the insider conversation between Commissioner Roseman and Brad Garlinghouse from November 9, 2018. Following these responses coming out in the public, XRP community is overjoyed. And a positive sentiment can also be seen in the market. Recent development has proved to be a good sign for the coin, as its XRP price has spiked in the last few days. The lawsuit is still under proceedings and can take more time to conclude. However, considering some facts provided and arguments made by both sides, it can be seen that the SEC has given many contrary statements and is trying to hide some facts. And if SEC turns out to be wrong in these cases, then it can indeed create distrust among the people for the government authorities. The next ruling will be the biggest decision in the Ripple case. Judge Sarah Netburn will soon be presented with the biggest decision in the Ripple, according to the opinion of XRP holders' attorney John Deaton. As it is known, the magistrate has recently ruled on the deliberative process privilege (DPP) issue with a few wins for Ripple, which were enough to be considered as a great result for the defendants and XRP holders, as Bill Hinman's speech was not found to be privileged, as well as related notes and drafts. The SEC then filed a motion for reconsideration as the plaintiff, arguing that what was once said to be a personal opinion is now being called public guidance. The 180-degree turn by the SEC has shocked many following the lawsuit, but Magistrate Netburn will literally be the judge of that. John Deaton, the attorney representing more than 65,000 XRP holders with amicus curiae status in the SEC versus Ripple case, has commented on the upcoming ruling, pointing to how critical it will be for the outcome of the lawsuit. It's all about XRP versus ETH. Judge Netburn's decision on the motion for reconsideration will be the biggest decision in the Ripple's case. I say that because I don't believe the motion to strike the fair notice defense is a significant one, because the judge isn't deciding whether Ripple had fair notice, but only whether it can argue it, he said. The final version does not refer to or mention XRP. The reconsideration motion relates to the 63 emails containing drafts and comments regarding the Hinman ETH is no longer a security speech. The final version of the speech discusses both Bitcoin and ETH. The final version does not refer to or mention XRP. Once someone understands how ETH was created and utilized, and how XRP was created and utilized, it becomes very logical to ask. For example, attorney Wendy Moore, a partner at Perkins Coie, a law firm very knowledgeable of both ETH and XRP, asked that very question. To be blunt, once you understand both ETH and XRP, it's impossible not to ask the question. Joseph Grunfest, who helped the ETH founder, explained this to the SEC in the December 17, 2020 letter. Likewise, the Perkins Coie lawyers, who advised both platforms, raised the same question. It's fair to assume that XRP was brought up in one of those emails. On June 13, 2018, we knew that a memo analyzing with respect to XRP was a security had been completed and did not recommend enforcement. If true, the mere fact that XRP was mentioned in the email as exculpatory. If Judge Netburn ultimately rules that the emails must be turned over, it is huge. But don't forget, even if the SEC persuades her that the emails are covered under the DPP, she can still pierce the privilege and order the documents produced. If she rules the emails privileged but orders the SEC to produce them, it means XRP is referred to and the evidence is indeed exculpatory. If the judge believes the evidence is exculpatory and Ripple has no other means of obtaining the evidence, she will pierce the privilege. If she overturns her previous ruling and decides the emails are privileged but doesn't pierce the privilege, the emails, although helpful to Ripple, are likely not as big as we perceive. That's it for today, guys. We will see you next time. Until then.